May I now request Honourable Lord Sir Justice Mark Potter, former Head of Family Justice for England and Wales, to address the gathering, please. Here. Mr. Mark Potter to speak.
Justice Balakrishnan and fellow justices and jurists, I was delighted as the representative of Lord Chief Justice of England and Wales, Lord Judge, to receive the award of this conference for his contribution to the administration of justice on his behalf. I should like, if I may, to convey his very great regret that he's unable to receive it in person, and to express to the conference in his own words his gratitude for the high honour which it represents. It's only the extremely pressing, and as I can say, though he would not, the arduous and burdensome nature of his duties in the United Kingdom which have prevented his attendance. He's asked me particularly to say that he has long admired the contribution of the judiciary of India, and particularly the decisions of the Supreme Court in upholding the legal and human rights of Indian citizens in a number of what may be described as tough and imaginative decisions, which have on a number of occasions succeeded in deriving specific and practical human rights, including rights to environmental protection, from a constitution framed in broad terms. Now, we live, of course, in an age where there's an increasing national and international recognition of certain fundamental human rights, a number of which are embodied with a greater or lesser degree in many of the by the constitutions, the domestic constitutions of many of the major states in the world, as well as in various international treaties and other instruments to which most of such states are parties, including, of course, the United Kingdom. One starts with the United Nations Universal Declaration of Human Rights in 1948 and proceeds, so far as the UK is concerned, to the European Convention on Human Rights, now incorporated into English law by our own Human Rights Act 1998. This has raised the necessity for our courts to examine closely and afresh the adequacy and the boundaries of a number of the rights and liberties hitherto recognised only in common law as freedoms within our unwritten constitution. In the face of the increasing threat of terrorism worldwide, and in particular in the United Kingdom, a number of those decisions have related to the treatment of those suspected of terrorist activity and the extent to which they may be detained and tried or deported for their activities or otherwise controlled by methods and measures which fall short of the standards traditionally observed in our normal criminal processes of arrest, detention and trial. This is, of course, a problem facing all the great common law jurisdictions across the world. In this connection, so far as the UK is concerned, the lot of presiding over the House of Lords in a number of difficult cases fell to Lord Bingham of Cornhill, Lord Phillips, our present senior law lord's predecessor. And many of those here today will, I'm sure, have learnt of Lord Bingham's recent death after only a short illness, early in his retirement and still at the height of his powers and activities. It's a tragic loss to the world of jurisprudence. And in this respect, Lord Judge has asked that I should say a few words about Lord Bingham, and in particular about the institution which has only recently been formed in his name under the auspices of the British Institute of International and Comparative Law, and which may yet be unknown to this audience. It's called the Bingham Centre for the Rule of Law. It will take as its starting point and be based on the content of a book published earlier this year, simply under the name Tom Bingham, and entitled The Rule of Law. It's a book which has not only been widely applauded among lawyers, but also is an articulation for the intelligent layman of the ingredients and importance of the rule of law, as that phrase falls to be redefined in modern conditions. It remains based on the concept made famous and elaborated by Professor Dicey, who first used the phrase the rule of law in his book, An Introduction to the Study of the Law of the Constitution in 1885. And Tom Bingham's work has been described by our Prime Minister as prescribed reading for his ministers. Dicey identified three aspects of the rule of law as he perceived it in the common law tradition, namely the supremacy of the law over government power, equality before the law, and enforcement before the courts. civil law tradition had generally focused less on the judicial process and more on the nature of the law-based state. Lord Bingham has encapsulated the core of the idea of the rule of law as being that all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly and prospectively promulgated and publicly administered by the courts. He elaborates this into three short 8 principles. First, the law must be accessible and as far as possible intelligible, clear and predictable. Second, questions of legal right and liability should ordinarily be resolved by application of the law and not by the exercise of a discretion, ministerial or otherwise. Third, the law should apply equally to all, except to the extent that objective differences justify differentiation. Fourth, the law must